Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the Free Legal Advice Show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, as long as they relate to the English legal system, please feel free to contact us on the numbers that appears at the bottom of the screen. Two ways to get in touch. First of all, to speak to me live on air, you can call on the landline number which appears at the bottom of the screen. Standard local charges apply for that. Alternatively, another popular way of getting in touch is to send us a message on WhatsApp on the mobile number which appears at the bottom of the screen. So you can call me live, have a conversation live with me, or alternatively send me a message on WhatsApp and I can look at your message as it comes in and address that live on air. A couple of minor points before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. Sometimes it transpires that matters are quite complex. I need quite detailed information. Now, if it's the case that your query is very complicated, then I will ask you to leave your number with the control room and I will speak to you off air after having that more thorough discussion with you. Secondly, sometimes it transpires that I do need to look at documents before I can advise you properly. For example, for immigration law matters, sometimes you tend to find that the Home Office has written to our viewers, and for me to be able to advise you properly, I need to look at your documents. Now, if it's the case that I need to have a more thorough discussion with you, or I need to look at your documents before I can advise you, then I will ask you to leave your number with the control room and I will arrange to have that thorough discussion with you, or I will arrange for you to send those documents in and I can look at your documents and advise you properly. As always, as this is a service that we provide as part of the Free Legal Advice Show, and it's completely free of charge, so you don't need to worry about any costs associated with the advice that we provide either live on air or after the show's finished. If you've asked us to have a discussion with you or if you've asked me to look at your documents, I can do all that and it's completely free of charge and part of the service that we provide here at British Muslim TV. Now, as I said, a popular way of getting in touch with us is to send a message on the mobile number which appears at the bottom of the screen. People don't necessarily want to come live on air where the matter is quite confidential and sensitive, so it's an excellent way to get in touch with us. And as always, we've had a number of questions that have been coming in even before the show started. So what I will do is start addressing some of those questions. The first question that's come in relates to an immigration law matter, and we've had many of these questions before, and it really relates to the current delay on the part of the Home Office in processing applications. And really the question is, how long currently do applications take to process? A lot of people have submitted applications, whether it's abroad or it's within the United Kingdom. Maybe it's for a spouse visa, you're calling your partner to the UK, and that's the immigration application you've submitted. Or your partner's here and you're submitting an extension application from the United Kingdom. So there's a real concern as to how long these immigration applications are taking. People are frustrated, obviously, by waiting, not knowing how long applications are going to take. Now, what I can do is, here on the show today, I can provide you with a rough guide in terms of how long applications are taking to be processed. Now, all applications are different. There may be reasons why one application might take longer, another might be processed more quickly. But I can give you a general idea as to what's happening with processing times. First of all, if, for example, the application has been made from abroad, typical application, somebody in the UK sponsoring their husband or wife to come over to the UK, if they made an application from abroad, typically that takes about 3 months to be processed. That's generally a good sort of guide in terms of processing times. Most people will get a decision within 3 months of the biometric enrollment date or the date when the passport is handed in by the applicant who's abroad. So that's a good indicator in terms of processing times. Within the UK, processing seems to vary. You may get a decision within 3 months. You may get a decision within 4 to 5 months. But generally speaking, most applications are currently being decided in terms of time frame between 3 to 5 months. So hope that answers your question. There is a delay. It's something which is completely out of your control, out of the control of your lawyer. There isn't much that he or she can do. It really just depends on the Home Office in terms of what their backlog is, how many staff they've got working, and other associated factors. So you've got to really be patient. Currently, it's likely to take, in the UK, between 3, 4, 5 months to get a decision. Hope that answers your question in terms of processing times. This is a question that comes up regularly, even before our Eid break. These questions were coming up frequently. How long is it taking? So out of country, applications are being decided in 3 months. In country, 3, 4, 5 months is a good indicator. Okay, let's look at the next question that's come in. Now, it's a very long question. Let me read the question out. It's from a brother called Raza, who's gone to a lot of trouble to set out his question in detail. But what I will do is, we do have somebody on the phone wanting to speak to us. So let's go there first and then return to this question that's coming from brother Raza. Let's take our first call. Hello, assalamu alaikum.
वालेकुम सलाम अलियास भाई क्या हाल है ठीक हो
जी अल्हम्दुलिल्लाह ठीक है आप कैसे हो ठीक
अलियास भाई मेरे दो क्वेश्चन है क्या कि एक पूछना है क्या कि अभी तक कोई अमेस्टी आई है या नहीं आई
जी
और दूसरा मेरा क्वेश्चन ये है कि पाकिस्तान से वर्क परमिट से आदमी मंगवाना हो उसका क्या तरीका है तीसरा मेरा क्वेश्चन ये है कि एक मेरा फ्रेंड है उसके पास एक बच्चा है क्या उसको भी अप्लाई करना चाहिए उसका बच्चा 2 साल का है ब्रिटिश उसकी वाइफ है ठीक है
ऑलराइट तो बच्चा भी ब्रिटिश होगा
तीन क्वेश्चन है
जी ऑलराइट है भाई थैंक यू वेरी मच आपका क्वेश्चन के लिए आप सुनते रहो मैं ये क्वेश्चंस को आंसर करूंगा जज़ाकल्लाह थैंक यू आपके कॉल के लिए सो द कॉलर who's called in he's asked 3 quite interesting topical questions first of all he asks in relation to whether there is any proposal to bring in amnesty bring in an amnesty for those who have overstayed in the United Kingdom. The second question that he poses, again very topical and interesting, relates to what the situation is with the new work permit scheme. And the third question he poses is in relation to somebody who has overstayed in the United Kingdom, has a child here who's British, and whether the person who's overstayed in the United Kingdom can do anything to regularize his stay in the United Kingdom. Okay, so 3 very interesting questions. Let me do this. Let me take the next call and I will address these questions in greater detail at that stage. Hello, assalamu alaikum. Hello.
Hello, assalamu alaikum, brother.
Ji, walaikum salam. Ji, thank you for calling.
Yes, brother, I have a question regarding, actually, I'm waiting for my hearing.
Okay.
And my hearing is like, it's been like, I'm waiting for the last 7-8 months. And it's still not has been done, but I did expedite request and that has been granted.
Okay.
So I just want to know how long it will take my hearing from now.
Okay. Did you say that your request for the hearing to be expedited has been granted? Is that what you said?
Yeah, that has been granted. They accept my expedited request.
Excellent. If it has been expedited, then potentially the court could fit in a hearing if all the parties are ready to go in the space of 2 weeks. It won't necessarily take that long. It's just the question of the next slot coming available. And a lot of our experience is with the tribunals up north. And in my experience, expedited hearings seem to be fitted in very quickly. in the space of about 2 weeks, 3 weeks, you get a hearing date. So down,
3 weeks, yeah?
down south, it may be slightly busier, but an expedited hearing shouldn't take more than 3 weeks or so to be listed. Because what you've got to remember is the tribunal has a lot of cases booked in. A lot of cases fall away. People withdraw their appeals. The Home Office decides to review matters and make a positive decision. So slots do become available. So it's just a question of whether the listings officer at the tribunal, bothers to put your case in when other cases drop out. So if somebody's on it, you could potentially get a very quick date. What I would do in your situation is, if you don't get a date within the next week, 2 weeks, just push the tribunal, just remind them that, look, you did agree to expedite my hearing. Can we have
sorry, how can I remind him? How can I contact him?
Literally, all you need to do is fax the tribunal. Your case would have been allocated to a particular tribunal, whether it's London, Bradford, Manchester. If you fax that tribunal directly, they should be able to hopefully keep your case on the top of their pile and give you a date as soon as... that's the tip I would give you. Fax the tribunal directly. Hope that answers your question. We're going to be taking a break shortly. If I haven't answered your question properly, or if you've got follow-up questions relating to your expedited hearing, please do call me after we come back from our break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. This is the second part to the show. Now, to speak to me live on air, please ring on the landline number which appears at the bottom of the screen. Alternatively, as always, you can send me a message on the mobile number which also appears at the bottom of the screen, and the message that you send to me will be fed through to me here live in the studio, and I will be able to address your questions. We've had a number of questions that have come in on WhatsApp, but as always, to speak to me live on air, please do feel free to pick up the phone and give me a ring on the landline number. Now, very quickly, what I want to do is, just before the break, we had a caller who called in and asked 3 questions. And I want to just run through those 3 questions and then go to the questions that have come in on WhatsApp. The first question that was asked of us was whether the Home Office had any proposals to introduce an amnesty for those who have overstayed in the United Kingdom. Now, the short answer to that is that there is currently no proposal whatsoever to bring in an amnesty for those people who have overstayed in the United Kingdom. Now, the talk about an amnesty being brought in really has been taking place for the last 2 to 3 years. And it's a comment made by Boris Johnson when he wasn't a Prime Minister at that stage, where he sort of floated the idea that potentially an amnesty could be introduced for those who have overstayed in the United Kingdom. Certain conditions would apply to that, etc. However, over the last 3 years, nothing really has happened in terms of moving this forward. So there is still talk about an amnesty within the community of people who have overstayed, but there is certainly nothing concrete from the Home Office in relation to this. Now, what I always say to clients who ask about this is you have to realise that there are a lot of other things have happened which are more pressing for the government in terms of dealing with Brexit, and that had a direct effect on immigration. So Brexit resulted in free movement coming to an end. People from Europe couldn't come into the UK to work, which resulted in a completely new scheme for European nationals and their family members being introduced by the Home Office. A lot of work was done there. Then, separately from that, a lot of work was done in terms of introducing the new work permit scheme. So amnesty is something that has really been left on the back burner. It may happen, it may not, but at this moment in time, there is really no proposal on the part of the Home Office to introduce an amnesty. Second question that was posed was in terms of the new work permit scheme. Yes, there is a new work permit scheme in place. It's the skilled worker scheme. Much easier than the old scheme. Easier in the sense that now employers in the United Kingdom are able to recruit from outside the UK without necessarily having to test the resident labour market here. So there's no need to advertise, there's no need to try and find somebody here. If an employer has a vacancy and it's a skilled level vacancy, it doesn't have to be professional level, so we're not talking about doctors and accountants and engineers anymore. As long as it's skilled level, there's a vacancy, a genuine vacancy, employers now have a free hand to employ people from abroad. So yes, there is a work permit scheme that's now come in, and it's much, much easier. So absolutely, work permits is quite a topical, interesting issue at the moment. It is much easier for employers, whether they're restaurants, whether they're factories, whether they're takeaways, to employ somebody from abroad to come to the United Kingdom. Obviously, there are some conditions. For example, the post that's been filled has to be at a skilled level. It can't be a very, very basic post, but at the same time, as I said earlier, it doesn't have to be professional level. As long as it's a skilled trade, you can potentially fill a vacancy with a foreign migrant. Obviously, there's an issue about salary. There has to be a minimum salary of £26,000 per annum. So, and there is another requirement which sometimes people struggle to fulfill, which is the person being recruited has to be able to speak English at a reasonable level. So there is a work permit scheme, substantially, significantly easier than the old scheme. However, there are certain conditions which still need to be satisfied. It's got to be skilled work, it's got to have a certain salary level, and the person being recruited has to have a reasonable command of English. Now, having said all that, the scheme is still significantly easier than what we had previously. I hope that answers the question. Last question that was posed to us was in relation to somebody who has overstayed but has a child in the United Kingdom who is a British citizen, and the child's been living in the United Kingdom now for 2 years. What can this parent do, the parent who's overstayed? It is possible for the parent who's overstayed to make an application to stay in the United Kingdom, to get a proper visa to stay in the United Kingdom based on the child. One of the requirements is that in terms of the child, the parent who's overstayed either has to be living with the child, or alternatively, if parents have separated, the parent who's overstayed must have contact with the British child. So, in terms of those people who have overstayed in the United Kingdom, it is perfectly possible for them to regularize their stay, get leave to remain in the United Kingdom based on a child who is a British citizen. Hope that answers those questions. Now, we've had a number of questions coming in on WhatsApp. Let me start addressing those. Long question from Brother Raza, who's texted in. Let me read the question out. I've not seen this question before. Let me read this out and let's see what the issues are and what the best way forward is. Brother Raza says, I want my parents to live with me here in London. They are Pakistani and currently living in Canada, as they are citizens of both countries. So they're Canadian citizens and they're Pakistani citizens currently living in Canada. Father born in 1951, mother born in 1953. So that would mean that they're in their 70s. I'm their only son. Both of my sisters are married in the United Kingdom. I don't have family in Canada. Is it possible to do anything? Now, in terms of Brother Raza, who's texted in terms of his circumstances, he says, I am a civil engineer working here in London who can provide for them and look after them with ease. Your advice and guidance would be highly appreciated. Now, to be quite honest, this is a question that arises quite regularly at the moment, where you, generally speaking, have a son here. In certain circumstances, it may be that the daughter's here. Son or daughter has been living here for a number of years, well settled here, in good employment, have decent money coming in, have accommodation, have savings. So everything's in place for them to look after their parents who are abroad. If they were to come to the United Kingdom, everything's in place for them to be looked after without recourse to public funds. So money's coming in to provide for them accommodation is available to provide for them, savings are there to provide for them as well. The question is, as Brother Raza says, is it possible for them, mom and dad here in this situation currently in Canada, to come to the United Kingdom to live here? And I assume when he says live here, he means to live here permanently in the United Kingdom. Now, the difficulty is this, that there was a scheme up until 2012 whereby parents over the age of 65 could be sponsored to come to the United Kingdom to live with their children in the United Kingdom. All you had to show was two things. First of all, parents are over the age of 65. Secondly, all you had to show was that they are financially dependent on you. Normally, these conditions were easily met. Parents could come to the UK and live here with the children. That rule or that scheme was unfortunately removed in 2012. It's one of the things that the Conservative government did when it came in. So in 2012, the scheme whereby parents could come to the United Kingdom and settle, that was removed completely. And those who have gone through the immigration system might be aware, when you're sponsoring husbands, wives to come to the United Kingdom, there is a financial requirement that has to be met. Again, that was introduced in 2012. So this is one of the things that happened in 2012. Since 2012, it has been virtually impossible to sponsor parents to come to the United Kingdom to settle. So what's possible now? Realistically, they are only able to come to the United Kingdom as visitors. Now, the good thing here is this, that they are Canadian citizens or they are living in Canada, so they'll have residence rights in Canada. So it's very, very easy for them to come to the United Kingdom as visitors. If they've got a Canadian passport, they don't even need a visa. They can come to the United Kingdom. If they've got permanent residence there, not a Canadian passport, they'll apply for a visitor visa and come to the United Kingdom. So that aspect is easy. So what you could do is over time build up their residence here, and if they are visa nationals in the sense that they need a visa, try and get a longer 5-year, 10-year visa, and every time they come, they stay for 3-4 months, go back, stay in Canada for 3-4 months, come back again. So you have to use the visitor scheme really to try and stay here, because at this moment in time, there is no way of them coming here to stay on a permanent basis as your parents. Now, having said all that, sometimes what you do is you try and look elsewhere, look at other schemes that they may qualify under. And I note that your parents are in their 70s, so other options are unfortunately very limited. Other options, if they were younger, could have been for them to come on a work permit scheme to be sponsored by an employer here. So what you do is you sidestep the rules relating to children sponsoring their parents. You look at alternative routes of coming to the United Kingdom. Here, parents are in their 70s, so that may not be a viable, attractive option. So that was always one route. Other route, again, not a viable option, would be something like a student visa to come to the United Kingdom that allows them to stay here on a longer term basis. So all you have to do is really look at the schemes outside the child-parent route. Because if you simply look at whether a child like yourself, Brother Raza, whether you can sponsor your parents to come to the United Kingdom, it's impossible to do that. There simply isn't a scheme. Now, when you look on the internet, when you look at the Home Office website, you will come across a scheme called the Adult Dependent Relative Scheme. And I mention that simply because a lot of people do Google stuff on the internet and they come across this and they think, well, maybe we fit into this rule. And I will address this after we come back from our break. But that scheme, the Adult Dependent Relative Scheme, is virtually impossible to come under. It's a scheme really for severely disabled people who are really unable to be cared for. There's no professional care services available in the country that they're in. It's an impossible scheme to come under. I'll look at that in greater detail after we come back from our short break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, to send me a message, please send me a message on the WhatsApp number that also appears at the bottom of the screen. We've got a caller waiting. Let's go to our caller. Hello, assalamu alaikum.
Hello, assalamu alaikum.
Wa alaikum salam. Thank you for calling. What's your question? Brother, you're live on air. What's your question?
Yes, my question is this. Can a Tier 2 dependent switch their visa to Tier 2 main applicant for the other company? Not for the same company as she came for, but for the other company. Can she switch it?
Right. The rules on Tier 2 have changed in January. So obviously it's a skilled worker scheme now. I am 99% sure it is possible to do that. What I will need to do is just double check on that. I'm 99% sure it is possible to do that. What I will do to give you a definitive answer is we'll probably be taking a break in the next 10-15 minutes, a short break. So what I will do is just check the rules. The reason for that is in January they changed the scheme. I just want to make sure that under the new scheme, the skilled worker scheme, a Tier 2 dependent can go into the skilled worker scheme. My recollection is that they can, because more or less everybody now can go into the skilled worker scheme except for visitors. So more or less everybody can go in. You don't have to be within the points-based system like you used to. But I'll give you a definitive answer. What I will do is, it's difficult for me to check live on air. So what I will do is when we go for a break in about 10-15 minutes, I will check it. And after we come back, that's the first answer I will provide. But I am 99% sure it is possible to do that. But I'll give you a definitive answer after we've come back from our break in about 10-15 minutes.
Okay. Thank you. Thanks
Brilliant.
a lot.
Thank you very much for your call. Jazakallah. Thank you for your call. We've had loads of questions coming in on WhatsApp, and I should really start going through them and do justice to them. Okay, let's look at the next question that's coming on WhatsApp. Our brother says, hi, Brother Kamal. Hi, I have a tenant. She sent me a text message to meet her at my property to give my keys back and vacate the property. But she lied to me. She's not giving the keys back, and she has even stopped paying the rent. And in addition to that, she has changed her number and I can't contact her anymore. Can I break the door lock, check the property again, or is it a trap? And she may claim against me for unlawful eviction. Brother Kamal, interesting question. The short answer is you can't go into the property at all. Under no circumstances should you break down the door, should you go into the property. That's a complete no-no. There are, as you correctly point out, there is a law relating to unlawful eviction. It doesn't matter if the tenant stops paying your rent. It doesn't matter if they're not letting you come into the property to inspect the property. It doesn't even matter if they are not looking after the property. You can't simply go into the property forcefully. So, going into the property without consent of your tenant is a complete no-no. And I'm sure you wouldn't do that. But the problem is this: somebody who does that could potentially be taken to court for unlawful eviction, and there are significant damages which are payable to a tenant who's been unlawfully evicted. The court doesn't look at where the fault lies. So the court doesn't look at the fact that the tenant wasn't paying rent. The court doesn't look at the fact that the tenant had prevented you from inspecting the property, or that the tenant had damaged the property. The court doesn't look at that. The mere fact that you've gone into the property of your tenant without consent, that's enough for a successful claim for unlawful eviction. Damages could be anything in the region of £5,000-10,000, etc. So definitely steer clear of that. What should you do? Well, if a tenancy agreement has come to an end, or if she's not paying her rent properly, you need to serve a notice on her, Section 21 notice, or whatever the notice is, If you're not sure, if you go on the government website, it tells you what kind of notice you need to serve, when you can serve it. If you're not sure, speak to a property lawyer. They will advise you in terms of what you should do. You must serve notice. You must wait for the notice to expire. After that, you must start county court proceedings in order to obtain an order from the court requiring the tenant to leave. And if it still doesn't happen, you'd have to instruct bailiffs to forcefully remove them. So these are the steps. A notice has to be served. After expiry of the notice, you have to issue proceedings for possession proceedings, wait for the order to be granted, instruct bailiffs to enforce the possession order. At no stage should you really go in. You should really follow those steps. So landlords are in a very difficult situation. Their hands are tied behind their backs. What can you do? This process could take 6 months, 9 months, depends how busy your local court is, but you must follow that process. Okay. Hope that answers the question, Brother Kamal. If you're not sure, as always, please do come back to me and I will give you more guidance in relation to that. Okay, next question. We've still got a number of questions to run through. Say, Assalamu alaikum, I have a very important question. It's a family matter. I got married 4 years ago with a European Union woman. We've been together since 2019. That doesn't, married 4 years ago, together since 2019. Maybe doesn't make sense, but definitely it looks like they have been together for about 2 years or so. 2020, we had a baby born in the UK, have pre-settled status. My partner, this is the unfortunate part, my partner keeps on menacing me, threatens to email the Home Office to cancel my visa. She keeps on saying, don't come home anymore. Question, can the Home Office take off my visa? I'm assuming the brother is saying, can the Home Office cancel my visa? What do I need to do to protect my situation? Okay, look, slight uncertainty as to how long you've been together. The dates don't quite match up, but the law is this. If you're married to a European citizen and you have been married for 3 years, so you look at the date that you got married legally, have 3 years passed since you legally got married? So if the answer to that is yes, and in those 3 years you have spent 1 year in the United Kingdom, I think there is no problem, because you've got pre-settled status. You must have spent a year in the UK, or you must have probably spent more than that, I think. So if you've been married for 3 years legally, and you've spent 1 year in the United Kingdom, then you have a right to stay in the United Kingdom based on your own previous residence in the United Kingdom. You have retained rights of residence. So that's what it's called, retained rights of residence in the United Kingdom. Now, what happens is this. Let's say you go through a divorce. So you start divorce proceedings. It doesn't matter, you can if you want to, or your partner starts divorce proceedings. Once divorce proceedings are instigated, once they ongoing, you can change your visa from the visa that you currently have, which is based on your partner as a family member. You can change it to a visa which you hold in your own right, based on your retained rights, based on 3 years of marriage and 1 year's residence in the United Kingdom. If you were to divorce, as at the date of divorce, if you've been married for 3 years and you've lived in the UK for 1 year, you've got the right to continue living in the United Kingdom as a consequence of that. It doesn't matter if you're divorcing, it doesn't matter whether you've got a child or not. Married for 3 years, lived in the UK for 1 year, you've got retained rights of residence. So if you go through a divorce, there's nothing to worry about. It's a simple application that you would make basically to get retained rights of residence. Retained rights of residence, you'd get it for 5 years. However, once you've lived in the UK for 5 years, 3-4 years with your wife, 1 or 2 years under the retained rights of residence visa after you've divorced, you can combine that once you've lived in the UK for 5 years, you qualify in your own right for settled status in the United Kingdom. Hope that gives you some comfort. There is a way out. There is a solution for you. So if, look, things don't get better, as far as your immigration status is concerned, there isn't really anything to worry about. You do have the right to continue living in the United Kingdom. Hope that answers your question. I know from the way you've written that this is something that is of great concern to you. If you're not sure about the answer that I've given, please do come back to me. Either send me a message or give me a ring, and I will address your follow-up questions. Okay, now let's look at the next question that's come in. Salam's brother, I'm from Manchester. Update me about Brexit. How a British passport holder can bring family in the United Kingdom. Somebody who has Spanish residence. What is the advice now? Obviously, Brexit occurred a while ago. The implementation of that, the ending of free movement rights, happened in stages. Free movement rights really came to an end 31st of December 2020. The Home Office gave people an option to still try and bring their family members into the United Kingdom up until the end of June 2021. Now, free movement rights have come to an end completely. So the effect of that is this. A European national who hasn't lived in the UK previously can't now come into the UK to live here on a permanent basis. They can come here to visit, but they can't come to the UK to live in the UK on a permanent basis. If you want to sponsor your family members to come to the United Kingdom, unfortunately, it's going to be difficult to do that. You can't sponsor as a European national. You can't sponsor your family members, such as your parents to come to the UK, grandparents to come to the UK. You can still sponsor your spouses to come to the United Kingdom. Now, if you're a British passport holder and you've lived abroad and you've lived with somebody from out of the EU and you want to now bring them to the UK, that may still be possible for a limited period of time. If you as a British passport holder have lived in Europe with a spouse, it may still be possible to bring your spouse to the UK. It's a complicated matter. I'll look at that in greater detail later. We're taking a break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. Just before the break, we had a caller who'd called in with an interesting question relating to somebody who is currently in the United Kingdom on a Tier 2 dependent visa. So they're here on a Tier 2 dependent visa, and the question that was put to me was whether a Tier 2 dependent visa holder, whether they can switch into a Tier 2 or the skilled worker visa. So whether it's possible to go from a Tier 2 dependent visa, somebody who's the partner of a Tier 2 visa holder, so a dependent, can they go up to a skilled worker visa? And I said, look, I'm 99% sure you can, but I would look at the position when we take a break. I have had the chance to look at it. And as I said earlier, and I've now confirmed it, it is possible for a Tier 2 dependent to switch into a skilled worker visa. So basically, they're sort of like going up from a dependency visa into the Tier 2 or the skilled worker visa. It is permissible to do that. Previously, there were difficulties in terms of switching visas one to another, but the new skilled worker visa that's come in, the replacement for the Tier 2 scheme, that has much greater flexibility. It's easy to move around. So absolutely, in terms of your position as a Tier 2 dependent, you can certainly move to the skilled worker visa. That's no problem at all. Hope that answers your question. Okay, now, just going back to some of the other many questions that have come in, and I'm going to have to be quick because I've got a number of questions to go through. Next question. hello, for the graduate route visa application, I have entered BRP as the identity document. When I fill in the IHS form, it auto adds BRP into the passport and travel document section, and it cannot be changed. Since the BRP is not a travel document, will this affect my application? Okay, I mean, normally what you would do is when you're doing applications, when you're doing the online form, there are normally specific questions about your passport. So it will ask you about your passport, the name in your passport, the issue expiry date, the passport number, etc. I hope you've got that right. If you haven't and you've paid for your application already, you've really got two options. Now, if you can cancel the application and redo it properly, fine. If you can't cancel the application because that would mean that your visa's expired and you're going to run into difficulties, maybe your visa expired last month and therefore you've had to put this application in, then just carry on. As long as you get your fingerprints done at the visa centre, as long as you've done your biometric enrolment, you can always add a note to your application. You know, when you upload your documents, your passport, your BRP and your degree certificate, you can always put a letter in explaining, if you think you've made a mistake, explaining what you've done. Caseworkers are generally okay. They'll realise what you've done and they'll amend the system, amend their records accordingly. And if there's been a mix-up, I mean, we've done that before where there's been a slight problem with the date of birth or the address or the telephone number. We've just simply added a note and said, look, there's a problem here. They've normally then just updated their system and sorted things out. So my view is, if you have made a mistake, and I can't tell at the moment whether you have or not, if you have made a mistake by entering the wrong details, then if you have time, just cancel the application, you get a refund and resubmit it. If there is no time to put it right, then just carry on. If you're concerned with the documents that you will be submitting with the application, the documents that you scan and upload, simply add a letter in there explaining what's happened if there is an error. But otherwise, I can't see a problem. Minor errors like that doesn't really cause a problem for the Home Office. They will work around that. So don't be concerned too much about that. Hope that answers your question. Okay, the next question that's come in, let me read it out. I will be applying for my husband to come to the United Kingdom from Pakistan in September. Just wanted to ask if it is better for me to send over to my husband the documents to take to the embassy in Pakistan, or I should apply from the UK. And if so, from the UK, which website do I use? Now, the situation is this. The documents is a separate matter. In terms of the application, it doesn't really matter where you are applying from Pakistan or whether you are applying from within the United Kingdom. The location doesn't matter because it's an online application that you're doing. The online application which lives within the Home Office website, it's there. So it doesn't really matter where you access that from. The application form is the same. In terms of documents, there is normally a choice. In terms of supporting documents, your husband who is in Pakistan could potentially take the documents to the visa centre, pay an extra fee and get the documents scanned there. Or you have a choice that you scan your documents here and you upload the documents onto the Home Office agent's website. So the website which is used by the Home Office for Pakistan, it's the VFS website. That website is used to book the biometric enrolment appointment in Pakistan, and that website is also used as a portal into which you upload your supporting documents. So in answer to your question, it doesn't really matter where the application is done from. My view, my personal view is, if possible, do the application from the United Kingdom. In Pakistan, what tends to happen is this, that those who are applying to come to the UK, they tend to go to an immigration agent there. They're not qualified immigration consultants. They're not immigration lawyers. They have some basic knowledge of form filling. And in my experience, they're okay when it comes to simple visitor applications, but they're not aware of the rules when it comes to spouse applications. Spouse applications have very specific rules about the documents which need to be submitted, specific rules about how old documents can be, specific rules about format for documents, etc. Now, the problem I have come to realize is that agents abroad don't have sufficient knowledge and experience and expertise in UK immigration law to be able to do the application properly. So what I would advise is either you familiarize yourself with the rules here, you look at the guidance here, and you do it yourself here, or alternatively, like most applicants do, you instruct a lawyer here either to review your documents or alternatively to do your application for you. I would strongly recommend that because there is always a potential for things to go wrong. It's one of those things where if you've done it a number of times, you've seen it done a number of times, it's not too complicated. But in my experience, if you're doing it for the first time, it is quite daunting. You will need either somebody who's done it before to assist you, or you'll need an immigration lawyer to take you through the process. So in terms of the online application, it can be done from here or there. Now, how do you find this online application? It is on the Home Office website. If you were to Google UKVI spouse application entry clearance or sponsoring a partner to come to the United Kingdom, if you get a hit on Google for the Home Office website, it should take you, if you have a look around, it should take you to the page from where the application is made. So it is on the Home Office gov.uk website, and it does say, are you sponsoring your spouse from inside or outside? So you would select outside, and then that would direct you to the right page. It asks you what type of application are you making. Are you sponsoring your partner or your child? You would say it's a partner, and then it's the process, online process then starts. So it is important you get to the right page, you select the outside application category, and you select the partner category, and then you carry on from there. So it is possible, whether you do it from here or there. My view is, if you're not going to instruct a lawyer to do it yourself here after looking at the guidance. In terms of documents, which is at the very, very end, my personal view is that you scan your documents properly here and you upload them yourself, or if you're instructing a lawyer, you get your lawyer to upload it. I wouldn't trust anybody else to do it and to get it right. So, you know, even documents, let me run through the kind of documents you would be submitting. You know, a copy of the applicant's passport, a copy of your passport, the English certificate, the TB certificate, the marriage certificate. If somebody's been divorced before, the divorce certificate. If the application is based on employment, normally 6 months wage slip, 6 months bank statements, a letter from the employer, proof of accommodation, whether it's parents who own it, a proof that they own it, property inspection report confirming there's enough space in the property, a letter from the owner, parents, if that's the case, confirming you and your husband can reside at the property, and then evidence about the relationship, wedding photographs, other photographs together. So there's a whole host of documents that you need to submit. And my view is, if you're doing it yourself, scan your documents in some kind of order, upload it onto the Home Office agent's website, the VFS website. Now, having said all that, I have to say, in my experience, normally it is advisable to get some advice on this. If you don't want to instruct a lawyer fully because it's expensive, you should, in my experience, at the very least, get a lawyer to review your documents just to make sure you are on the right tracks. Very easy to make a mistake with these kind of applications. Look, I know you've asked general questions about spouse applications, location, where do you apply from, documents, where do you submit the documents? I hope I've answered that. This is slightly a complex issue. What I would say to you is, if you're doing the application yourself and if you have specific questions that you're not sure about, please do either send me a message or give us a ring. Get your questions together, what you're not sure of. Give us a ring live on this show, and I will answer those questions live on air. That brings us towards the end of the show. Thank you very much indeed for all the calls and the numerous messages that have come in on WhatsApp. Very grateful for that as always. We'll be back next week on Tuesday at 8 o'clock. So please do join us then. And as I've said, if you're not sure about anything, please do give me a ring and we can go through your questions then. That brings us to the end. Inshallah, see you next week.